Hey folks, this is Rob Wells with you from the Law Office of Robert M. Wells. Our office helps out landlords and property managers deal with their landlord-tenant situations and problems. In this video, we're going to talk about whether or not a fixed term lease, if that lease term expires, is that just cause under the Tenants Protection Act of 2019 or AB 1482. Before we begin though, landlords, property managers, if you're facing a situation where your lease has expired and you're wondering whether or not you can start an eviction or unlawful detainer action, or you have any other landlord-tenant situation or problem, please feel free to reach out to us below. Now let's begin. So we do kind of run into this question quite often about whether or not, if you have a fixed term lease, such as you have a 1-year lease from your tenant, let's say it just runs from January 1st to December 31st of the year, and guess what? The lease expires as of December 31st, 2022, for example. As of January 1st, 2023, could you terminate the tenancy, for cause because the lease term expires under the Tenants Protection Act? And the question, this question the answer is it depends. So let me backtrack for a minute to understand this issue. Before the Tenants Protection Act and landlord-tenant law in general, if you have a fixed term lease, it could be a day, it could be for a month, it could be for a year or 10 years. Generally speaking, at the end of the term, the landlord does not need to give notice of any type of termination of tenancy because the lease itself terminates itself by the terms. That's why they call it a fixed term lease. So in the old days before the TPA, if you had a lease and your tenant stays over or unlawfully holds over after the lease term, you could immediately file the eviction case right then and there at the day after the lease expires. And that's provided under Code of Civil Procedure 1161 Subdivision 1. Those rules apply. And for the most part, now since we have the Tenants Protection Act, if you're exempt from the Tenants Protection Act, yes, you can proceed with an eviction. However, if you're subject to the Tenants Protection Act, it kind of doesn't work that way anymore. There is a code section within the Tenants Protection Act. The subsection is Civil Code Section 1946.2 Subdivision B1 Paragraph E. Now, I'm going to have to read this to you to explain this. It states here, the tenant had a written lease that terminated on or after July 1st, 2020 or January 1st, 2022 if the lease is for a tenancy in a mobile home, and after a written request or demand from the owner, the tenant has refused to execute a written extension or renewal of the lease for an additional term of similar duration with similar provisions, provided that those terms do not violate the section or any other provision of the law. Okay, that's what that reads. Now let me get into this now. You're gonna go, Rob, what does that mean? So what it means is, instead of your lease just expiring, if you're a landlord subject to the Tenants Protection Act, you have to actually offer your tenant a renewal of their lease on same or similar terms for a similar duration. So for example, if you have a policy of, doing 1-year leases and you automatically issue a new lease and request that your tenant, execute a new lease form for another year duration, for example, that actually could qualify for cause under this code section. Now, as some of you may know, and in some of my other videos, I have criticized the Tenants Protection Act. One of the things I criticize the Tenants Protection Act about is just the terms of what is cause and what isn't cause. And if you ever practice landlord-tenant law, what's gonna, need to be flushed out with the Court of Appeals and or the state Supreme Court is what is in an additional term or similar duration with similar provisions. we have a lot of situations where some landlords, their written lease agreement may be one page. It may just have really simple terms like, hey, I'm going to rent to you the property, from January 1st to December 31st, and there are no other terms. What if you were trying to, get a standard boilerplate lease in lieu of that contract? Does that qualify as an additional term of similar duration with similar provisions? That depends really. And if I had a lease like that, we might have an issue in court because of the language of the Tenants Protection Act on its face. Hey, how did we go from a 1-page lease to a 10-page standard boilerplate lease, for example, to qualify? Also, the code doesn't mention what is, like a reasonable period of time to allow a tenant to decide that they're going to renew the lease or not. That kind of is unclear as well, too. I'll tell you what we've done in the past in similar situations. Generally speaking, when we're executing a new lease on same or similar terms, a lot of times, and I'll get more into this in another video about adding the disclosure required under the Tenants Protection Act for single-family homeowners if their lease was entered into on or after July 1st, 2020. There's a carve-out to add the disclosure that's required under the Tenants Protection Act, and that qualifies as a landlord asking you to execute a lease on same or similar terms. When we do a lease renewal like this or add that disclosure for the single-family homeowners, I generally give my tenants at least 30 days to, sign the addendum or sign a renewal lease before issuing a notice terminating their tenancy for cause. So the long story short answer is no, you can't just run to the courthouse and file an unlawful detainer if the lease expires. But you could require the tenants execute a new a written lease agreement for another year term, for example. That's if it has the same terms as your previous lease. That is possible. Or if you were trying to add the Tenants Protection Act exemption to your rental agreement or lease agreement because, your lease was older or you didn't have that before and you need to add that disclosure in, you could do that. Oh, another one just off the top of my head is leases. If you're subject to the Tenants Protection Act and you need to add a provision for owner move-in or a qualified relative to move in per the Tenants Protection Act, we'll cover that in another video too. That would count as a similar term for this paragraph, this paragraph E in the Tenants Protection Act as well too. Those are some things where you could just ask your tenant to renew the lease, and that could qualify as just cause. I might have confused y'all on this, and this is really highly nuanced. So if you need help with determining whether or not, hey, your request for renewal would qualify as an event where if your tenant didn't sign that new lease agreement, would that qualify as just cause? That may be something that you may want to run with a lawyer about, because again, language, they kind of left a little bit, a lot of the doors open on some of this. It's not exactly 100% clear, although, we do have these terms that guide us. You may want to talk to someone about this. And, this video kind of ran a little bit longer than I wanted to, but if you need help, looking at this and, you want someone to take a look at it, please feel free to reach out to us below and we can talk about that situation, because these are going to probably be highly factual types of scenarios that you're looking at. So until next time, folks, stay tuned. We'll be talking more about the Tenants Protection Act and some nuances and some things that I think are unclear. And until next time, folks, we'll talk to you then. Thanks.